This is Bloomberg Law with June Grasso from Bloomberg Radio.
It was spaghetti night last Wednesday at Cook's Corner Restaurant and Bar, a time when people in the tight-knit California community gathered to share a meal. But it became the scene of another mass shooting when a retired police sergeant came in armed with 2 handguns, fired at his estranged wife, and then began to randomly shoot.
We believe he traveled from Ohio with an ongoing dispute regarding the separation and pending divorce with his wife.
He killed 3 people and injured 6 others before he was killed by police. More than 2/3 of mass shootings are domestic violence incidents or are perpetrated by shooters with a history of domestic violence. That's according to a study by the Johns Hopkins Center for Gun Violence Solutions. And a case before the Supreme Court this term will determine the fate of a federal law that bars gun possession by people who are subject to a domestic violence restraining order. Joining me is Second Amendment expert Eric Ruben, a professor at the SMU Dedman School of Law. Eric, how important is this Supreme Court case?
It's a hugely important case, and it's a hugely important policy area because it deals with a modern-day restriction on gun possession by domestic abusers, in particular by people found by a judge to pose a specific threat of domestic violence and who are subject to a protective order. And the reason why this is so important is because we now know that women are 5 times more likely to die in a domestic violence situation if a gun is present. In fact, every month, an average of 70 women are shot and killed by an intimate partner. And what this decades-old law is trying to do is to remove the lethal means of a firearm from somebody who's been found to be violent to a spouse or someone else in the home.
So let's remind everyone of what the test is that was established in the landmark 2022 Bruen case.
So the Bruen case, which was issued in June of 2022, announced a brand new test for Second Amendment cases. In particular, after Bruen, the constitutionality of a gun law, like the one at issue in Rahimi, turns on whether the law is analogous in some ill-defined sense to historical gun laws and historical regulation of firearms. And by historical, the court said the late 1700s or perhaps into the 1800s at the time when the 14th Amendment was enacted. It's an unusual test. It's different from the one that governs other individual rights contexts. And in practice, what the Bruen case meant was that it didn't matter at all that all of the courts to consider the constitutionality of this domestic violence restriction before Bruen had found it to be perfectly constitutional because they'd applied a different test that considered contemporary costs and benefits. And in fact, litigants after Bruen got a do-over under this new historical analogical test, not just with respect to this domestic violence restriction, but with respect to all weapons restrictions.
The test makes no sense to me because how do you judge modern weapons that the framers could never have envisioned with a standard from centuries ago? Does it lead to less gun control regulations?
Well, I think that was one of the reasons why the Supreme Court, or at least the 6 justices in the majority, handed down this Bruen test. In the Bruen opinion, the majority said that the lower courts were being too deferential to legislative determinations of policy needs. And so, in effect, the test cuts out or at least minimizes the importance of modern-day assessments of what will keep the public safe. And in this particular case, the Fifth Circuit decided that the law contradicts the nation's historical tradition of gun regulation. And you raise an important point, which is how do you actually do this analogical exercise given how different things are today? They're different in terms of the technology of firearms today versus back in the age of muskets and muzzle-loaded guns. They're different in terms of our cultural norms, and our legal order is very different. And this case actually highlights these differences in a very stark way.
So tell us about the facts of this case and the procedural history.
In this case, the defendant, this is an appeal from a criminal conviction. The defendant, Zaki Rahimi, had assaulted his girlfriend, and then he actually agreed to a restraining order that prohibited from possessing firearms. He was later caught with a gun, and in fact, he had been firing the gun on a number of occasions, and he was prosecuted under a federal law that bars gun possession by people who are situated like Rahimi under a restraining order found by a judge to pose a specific threat of domestic violence. And he argued that that federal law violated his Second Amendment rights. The Fifth Circuit ultimately agreed after the Bruin case came down that this was a Second Amendment violation. And in terms of the procedural history, where we are is the federal government appealed or sought an intervention by the Supreme Court. And the Supreme Court decided late last term in June of 2023 that it was going to accept the case. So last week, all of the briefs in support of the government's position, in support of the constitutionality of this restriction were due, and a lot of briefs were filed. In fact, 38 briefs were filed last week, which I think shows the significance of this issue.
Did the Supreme Court almost have to take the case? How were the circuits ruling on this issue?
Yeah, so the Supreme Court has a lot of discretion about what cases it takes, but this case presented an issue and a conflict that made it hard for the Supreme Court to say no to it. In particular, it's a federal law that was struck down in the Fifth Circuit, and the Supreme Court tends to take cases where federal laws are struck down. And there also is just a lot of confusion in the lower courts about this issue and, frankly, all Second Amendment issues after Bruin. So the Fifth Circuit declared that this law was unconstitutional, but other lower federal judges have declared it to be perfectly constitutional. And that's reflective of what we're seeing over the past year in Second Amendment cases, where judges looking at the same historical record are reaching diametrically opposed conclusions about whether modern day laws are constitutional or not. And I think that it's very telling that this is happening, in particular because one of the reasons that the Supreme Court issued this historical test was purportedly to constrain judges. But the results of opinions that were issued over the past year show that that's not happening so far.
As you mentioned, there are more than 36 briefs filed by organizations ranging from women's groups to prosecutors to history scholars, and I know you submitted one. Can you characterize the nature of these briefs?
Sure. So, the briefs, I think, fall into three general buckets. Some are historical, some were methodological, and then some were just policy. There are a lot of briefs that are focusing on historical regulation. And that's because Bruin says that the constitutionality of modern laws turns on whether or not the laws are consistent with historical tradition. So, for example, 18 professors of English and American history signed on to a brief that was talking about why guns weren't frequently used in domestic violence situations at the founding, and in particular, just because the technology at the time didn't make them readily available in domestic conflicts. So no matter what we thought about domestic violence back in the late 1700s, we wouldn't expect to see the regulation of guns in the domestic violence context. And that brief also pointed out that our legal view of women was very different. Women were not viewed as equal to men in a legal sense, and there wasn't robust protection of those who were abused in the domestic context, even though there were some restrictions. So the brief and others that fall into this historical camp are looking a lot at what the shape of historical regulations were.
And I saw that one brief said that guns in use at the time of the founding weren't great weapons for crimes of passion because you didn't have handguns. And
no, these were muzzle-loaded firearms. In fact, it was unsafe to keep them loaded. There were some regulations that required that gunpowder be stored separate from the firearm itself because they were liable to misfire and start fires. And so in crimes of passion, and a lot of domestic violence fits into that category, people would grab whatever is close at hand, such as, sticks and rocks and blunt force objects, but not firearms, which took time to load and then use. So the historical context is incredibly important, and these briefs are arguing that the Fifth Circuit just didn't pay enough attention to that historical context. So that's a major thread.
And what about your brief? What was your argument?
So my brief, which I filed with Mariva Siegel at Yale, Joseph Locher at Duke, Daryl Miller at Duke, and Jake Charles at Pepperdine, with the assistance of Don Borelli at Munger Tolles, who was our counsel, was a methodological brief, more so than a historical brief. And in particular, what we pointed out is that a lot of the reason there's so much disagreement in the lower courts is because courts are not applying an even-handed analysis, an even-handed historical analysis to the scope of the right to keep and bear arms on the one hand and our tradition of regulation on the other. And in particular, there are some courts that are taking a super expansive view of what the right to keep and bear arms protects, but then applying a different lens, a narrow lens, to the historical regulations at the time. They'll say that all weapons are protected by the right to keep and bear arms, but then when looking at a regulation, they'll say, oh, only this particular category of person was disarmed at the founding, and that particular category of person is not the one that the modern regulation is disarming, and therefore it's not analogous. And what we're arguing as a methodological point is that if we're going to do this exercise that's set down in Bruin, courts should be doing it in an even-handed way. And if they were to do that, I think that the result in the Rahimi case would have come out differently.
Do all the briefs accept the Bruin test and are not trying to say that the Bruin test was wrong?
One interesting thing is that there were a couple briefs that argued that Bruin and Heller should be overturned because they've just proven to be inconsistent with the approach that the Supreme Court has taken to other issues like abortion and unworkable in practice. And so there were some briefs that were filed in this case that argue for a wholesale reversal of Bruin and even the 2008 decision in Heller that found an individual right to possess a handgun in the home for self-defense. But most of the briefs that are filed are accepting the Bruin test and then saying even under that test, the outcome should have been different because the historical analysis in the lower court was wrong, that the court didn't apply Bruin faithfully because it took a different approach with respect to rights on the one hand and regulations on the other. And then there's some briefs that are pointing out the important policy implications that are modern-day policy implications when it comes to domestic violence in the home.
Which of the conservative justices are these briefs trying to convince?
It's always hard to know what various briefs are trying to do or who the specific justice is, who the brief seeking to make their audience. But there certainly seem to be some briefs that are focused at the more moderate conservative justices like Kavanaugh and Amy Coney Barrett, who might join with other justices to make a majority and uphold this domestic violence restriction.
Even in the Bruin case, was it the Chief Justice and Kavanaugh who wrote a concurring opinion?
Amy Coney Barrett wrote an opinion, a concurring opinion, as did Kavanaugh and Chief Justice Roberts. And the concurrence by the Chief Justice and Justice Kavanaugh was interesting because it went out of its way to emphasize that the Bruin test, even though it's a novel test, is not a straitjacket and that it still permits ample regulation. And that opinion even went through a list of presumptively lawful regulations, such as disarming people who've been convicted of a felony and other restrictions that was in Heller, but Justice Thomas did not include in the majority opinion in Bruin. So it's possible that some of the amici who are submitting briefs are focused on justices like the Chief Justice and Justice Kavanaugh, who took the time and space to emphasize the limits of the Bruin decision back in 2022.
And we have yet to see the responding briefs in this case. That should be interesting as well. Thanks so much, Eric. That's Professor Eric Ruben of the SMU Dedman School of Law. Michael Bloomberg, the founder and majority owner of Bloomberg LP, the parent company of Bloomberg Radio, is a donor to groups that support gun control, including Everytown for Gun Safety. The National Labor Relations Board handed unions a victory with a decision allowing unions to represent workers without a formal vote. The NLRB's Democratic majority created a new test that resurrected elements of the standard from the board's 1949 ruling in Joyce Silk Mills. But unlike that earlier test, the new framework doesn't turn on proving that employers had a good faith doubt that unions have majority support in order to require them to recognize and bargain with unions. Instead, the new framework calls on employers to recognize a new union or promptly file for an election when the union asks for recognition based on a majority of workers showing support. My guest is labor law expert Anne Marie Lofaso, a professor at West Virginia University College of Law, and a former NLRB attorney. And do you want to give us a little background on this?
It is one of the most difficult areas of law. So I've simplified it. So there are two main ways for a union to get recognition. The first way is that the employer can voluntarily recognize the union based on a card check, and that would mean a majority of authenticated cards. Or the employer can reject the union's demand for recognition, and then the union has to petition for the election, and then the election is typically held within 5 weeks. Okay, so those are the two main things, at least up until this case. So now during the critical period, and that's the time between the petition for the election up to the election, the employer will typically hold something called captive audience speeches to explain why employees should not vote for the union. And studies show that if the employer holds 5 of these, the union has almost no chance of winning. So something like 94% chance of losing the election. But even one captive audience speech substantially lowers the union's chances of winning. Now, why, you might ask? It's because, one, these speeches are intended to dissuade employees from voting for the union. The union has no right to reply. And although these speeches are not per se unlawful, they often contain threats and other coercive conduct. So there's this big case called Gissel. That's in 1969, goes to the Supreme Court. And Gissel presented the paradigm fact pattern that is in this case. So what's the paradigm fact pattern? Hotly contested election campaign. Union obtains a card majority. The employer refuses to recognize the union based on the card majority. Lots and lots of unfair labor practices. Many of those unfair labor practices are called hallmark unfair labor practices. And then what happens is the union loses the election, even though it had a card majority, because of all these unfair labor practices. So if the board finds that the severity of these violations makes them likely to have a lasting inhibitive effect on a substantial percentage of the workforce, thereby making a fair rerun election unlikely, then it can issue what's called this Gissel bargaining order. Now, the problem with the Gissel bargaining order, even though the Supreme Court said, yep, this is fine, this is okay, by the late 70s and 80s, the courts are actually enforcing these orders, so they get harder and harder to enforce so that they're almost never issued anymore. The board doesn't even try.
So tell us about this case and the procedural history.
This case is the same fact pattern of Gissel. There's a card majority. Everyone agrees there's a card majority. And then there's tons of unfair labor practices, so the union loses the election. These unfair labor practices are all hallmark violations. So really scary things that are going to reverberate through the bargaining unit. The board says, we're going to overrule Linden Lumber. So when the union asked for recognition, the employer no longer can say no. It has two choices. It has to either say yes, or the employer has to file an election petition. Those are its only two choices. It doesn't have to say no and then make the union do it. It has to say either yes or say no good faith doubt. It doesn't have to have good faith doubt. I'm going to do the election. And the reason this simplifies the whole thing is because Joyce Silk was very difficult to enforce because the good faith doubt standard is very difficult to enforce. How do you figure out if the employer really has a good faith doubt? Gissel is hard to enforce. Here, you're just saying at the moment that the union says to the employer, we want recognition, here's our card majority, the employer has to make a choice, recognize or go to an election, and it can't dilly-dally. The election has to take place, and if it refuses to do that, that's an unfair labor practice. That's what this case is about.
So does this restore the practices of the Obama administration?
No, it doesn't. It actually changes the whole thing. This is not a case that is restoring something that Obama did. This is something that is different from anything the board has ever done. It's completely new. And remember, what's important here is not so much whether the employer recognizes or not the voluntary card check or there's an election. The really big problem is what happens when the employer engages in all these unfair labor practices that make a fair election impossible or nearly impossible, very difficult. What's the remedy? So the remedy here is to go at that moment when the union asks. The Obama administration would have said, when the union asks, the employer can say no and then just sit on its butt and do nothing. And then the union has to file all the election paperwork. And then there's all these hearings, there's all this stuff, right? And that was the way it was for a long time. And then after several years, if there's finding that there's all these unfair labor practices, once the union files the election petition, then you might get this thing called the Gissel bargaining order. Here, the employer has to say yes or no, has to commit. And if it says no, it has to file the election petition. And if it does anything during that time, it's an unfair labor practice. So it's actually a cleaner rule. It actually simplifies the whole rule. It makes it easier. I think it's going to be easier to enforce in the courts, which these other two, they're very difficult to understand and they're very difficult to enforce.
So this was a 2-1 decision and the Republican dissented.
Actually, even the Republican, right, even the dissent agrees this is egregious. What this employer did is egregious. And so he says, why are we even deciding this? Because either way, they get a bargaining order. And the majority says, well, because this presents the question and we can do that. So he doesn't even want to reach the question, but he doesn't like it anyway. He thinks it's a bad idea. But I actually think it's a brilliant strategy. Obviously, I can see why he's dissenting. If you're on the Republican side, but from the pro-employee, pro-union side, it's a brilliant strategy. Because if it's enforceable under either rule, the Supreme Court won't take it because it doesn't squarely present the issue. So that means they're going to have to wait for other cases to percolate. So it's actually a really smart strategy to allow this to kind of mature among the different courts of appeals to see how they deal with this.
Do you think this will be appealed?
Oh, definitely. No doubt. This is such a big case. There'll be a petition for review immediately.
What were some of the things the company was accused of doing that were so terrible in the labor board's eyes?
They threatened job loss. When you threaten people with jobs, they don't vote for unions. That they get really, really scared. They got rid of the main union organizer. Those were the main ones. But they also did coercive behavior almost daily during this election campaign. They would, constantly do things like we won't provide you with help. They wouldn't support the employees. They did everything they could to make the employees' lives very difficult. They said the employer violated the act when it deployed security guards at numerous plants for 2 weeks before the election at all the polling places. So that's intimidating. If you wanted to change the rule, this is the case you want, because even your most conservative board member is going to say, yeah, this is a Gissel, and any court is going to uphold a Gissel bargaining order here because it's so egregious. Now, there are two ways that the Gissel bargaining order might not be upheld, and this is where the problems come in, is if there's like a lot of turnover, then a lot of courts are really persuaded by that argument that, oh, there's all this employee turnover or there's lots of supervisory turnover. And the problem with that is that the Gissel bargaining order was supposed to attach back when there was a majority. And so they go, well, this is the future now. And that's why unions love this. I think the unions will love this anyway, because it says at that moment, the employer has to make a choice. Yes, we will recognize you, or no, we're not recognizing you, but we're going to the election. And once it does anything to then interfere with that election, it's an unfair labor practice. So it's sort of bringing it back to the moment that things are happening. So it's harder to make the arguments that have been successful in getting rid of these Gissel bargaining orders. And remember, what's the whole point of having an election? The point of having an election is not to win the election. It's to win the election so that you can then get a collective bargaining agreement So the whole point of the election is to get negotiations. So what the employer is doing here in these cases is it's basically terrorizing its employee workforce with threats of job loss and things like that, so that they don't vote for the union. And then there's a finding that they didn't vote for the union not out of free choice, but out of fear. So it was an inhibited vote. And so therefore, there wasn't really this freedom of association, which is guaranteed expressly by the Act in the words of the Act.
So how important is this decision then?
This is a very stunning decision because it does something the board has never done before. And it grounds it in the statutory language, which, remember, the Supreme Court likes. It's textualist.
Thanks so much for being on the show, Anne. That's Professor Anne Marie Lofaso of the University of West Virginia School of Law. Hawaiian Electric is being sued not only by victims of the Lahaina fire, but also by Maui County and investors. They claim the utility didn't cut power and take safety measures to contain the raging flames that engulfed the city of Lahaina. Joining me is Bloomberg legal reporter Joel Rosenblatt. Explain, the county of Maui is suing Hawaiian Electric for negligence. Explain what their claim is.
The county is the latest entity to file a lawsuit against Hawaiian Electric, which is unusual. In all the California wildfires that I've covered, I've never seen a county. You've seen a district attorney, for example, but not the county sue the utility. And they're suing the utility saying it started the fire. I understand from a little bit of reporting that I did that this is especially unusual in Maui, where there's a sense of community and everybody's trying to operate together, especially in an emergency like this. But to have the county turn on its own utility on that island is unusual and potentially problematic. But the claims are the same as the other lawsuits that have been filed, or similar to them, that the utility started the fire and the utility is responsible.
And tell us a little more about the specific claim of negligence.
The power lines blew down and sparked a wildfire in the grasses that then grew larger. There's an interesting ripple here because the utility has, in fact, responded by saying, you know what, it's actually the county's fault, because the utility has acknowledged that their power lines did indeed start a fire, which is unusual. That's unusual. That was news. But then what they say is that the fire, that initial fire, firefighters who work for the county, they put the fire out, but they didn't extinguish it. The winds came and blew those fires into what became the fires that destroyed Lahaina.
Have you heard what the response of the plaintiff's lawyers is?
I have, and the lawyers who have already filed these suits have said that doesn't matter because you started the initial fire that became the fire that burned down the town of Lahaina. And I should have said that the negligence claim is based on this argument that the utility knew these high winds were coming and should have, as is now done often in California, should have turned off its power knowing that the high winds were going to come and potentially blow down the power lines. So they're charging forward. They don't care. And they also, the explanation is a bit convoluted, and I don't know that the utility has empirical evidence that they indeed didn't start the fire that did all the damage.
So is it unusual to have the lawsuits before the official cause of the fire is determined?
Well, I've covered wildfires in California. I've covered the litigation from those wildfires, and based on that experience, hardly unusual at all. I mean, now in California, if there's a wildfire, it's a race to the courthouse. There's always multiple suits filed, and I think lawyers in this area, I mean, I actually know all the plaintiffs' lawyers now who are suing Hawaiian Electric, and they're in many cases the same lawyers who have sued PG&E in California. So, no, it's not surprising they file suit at this point expecting that the utility is liable.
And when you look at the numbers, I mean, it seems as if Hawaiian Electric is found negligent in all these cases, they're going to go bankrupt just as PG&E did.
That's correct. The lawyers don't really pay that much attention to the long-term health of the utility, and there's a good reason now. There's a model for them now in PG&E, which indeed was pushed to bankruptcy, but then kind of got back on its feet. And oftentimes, you know, what they're looking at is that the rates increased rates will be passed on to ratepayers, and the lawyers who are representing wildfire victims, they think they're going to get their money. There's some discussion now among plaintiffs' lawyers that eventually the federal government's going to have to step in and help this utility. That's a possibility. And if so, for the plaintiffs' lawyers, another target or another pocket, a real deep pocket.
Tell us about a suit in San Francisco. Is a securities fraud suit?
So, yeah, a variety of suits with a variety of claims. The one in San Francisco federal court filed last week is on behalf of investors. Hawaiian Electric is the parent company, which has seen its stock price just get hammered since the fire. And that's a securities fraud suit saying that the company knew that it had these problems, it had this exposure, that its lines could have been blown down. They didn't disclose it to investors, and they hid this potential problem that has ended up costing investors their entire investment. Interestingly, the stock price has since rebounded with this argument that we discussed previously that the utility is putting forward, that it's in fact the county's response.
So some of the plaintiffs are using a theory that was used in the PG&E cases that would mean that they do not have to prove negligence.
That's, to me, the most interesting claim. It's called inverse condemnation. It's a cousin of eminent domain, which is more understood, in which the government, for a government project, usually for infrastructure, takes private property and compensates the owner, usually a private owner, for that property. That's also another expression is that land is condemned for a project. So this is a relative of that doctrine called inverse condemnation. So you invert the condemnation, and this is a private property owner, in this case an owner of property that was burned by the wildfire, suing the utility for the damage, saying, electricity is a publicly provided resource, and you're using public or private land to run your power lines on, and you caused damage that was unforeseen, and I'm holding you liable for it. In California, you don't have to establish negligence. That claim can move forward without that burden of proof. And so there are lawyers here in this case who are using the same legal doctrine to try to sue Hawaiian Electric. There is a history of inverse condemnation in some contexts in Hawaii, never in a wildfire context because this is completely novel, completely new. Whereas this is well established in California, these lawyers are looking to import kind of the success of that from California to Hawaii. We'll see. It's completely untested.
And what might be one of the hardest parts of this case for the plaintiffs?
A key component, a key requirement of inverse condemnation is that you need to be suing a government entity. That's what's required under the doctrine. And so the fight is going to be whether or not the utility is a government entity. It's regulated by the government in terms of what it can charge, but it's investor-owned, right? It's a privately owned, investor-owned utility that provides a public service. So the lawyers who have filed this lawsuit and filed this claim feel like they're not going to have any problem showing that this is indeed a government entity that can be a target of inverse condemnation claims. But as was the case with PG&E, there's a big fight in California over whether or not the utility is actually a government entity, purely enough of a government entity to be the target or identified as the defendant in an inverse condemnation claim.
I know you'll be watching these cases closely to find out what happens. Thanks so much, Joel. That's Bloomberg legal reporter Joel Rosenblatt. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.